Climate justice, climate responsibility, and sustainable coexistence. To set the background, as climate pressures intensify, can adversarial processes alone secure a sustainable future? Or can mediation become the missing bridge between development and conservation, transforming conflict into collaborative stewardship? Look no further than July 2026. Iceberg A23A, which was found in the Antarctic region in the year 1986, spanning 4,000 square kilometers and weighing 1 trillion tons, is completely disintegrated in July 2026 within the warming South Atlantic seas. It proves a stark truth: when foundational systems face overwhelming climate stress, rigid structures fracture, and we talk about progress and development. But the issue to ponder here is that when zero-sum legal battles fail to protect a fracturing planet, can consensus building deliver true climate justice? In this context, I introduce to you our distinguished panel. The session chair for our panel is Honorable Mr. Justice Vashisht Kokaram. Ladies and gentlemen, it gives me an immense pleasure to introduce Justice Kokaram. Justice Kokaram brings decades of extraordinary judicial, legal, and academic experience to the bench. A pioneering advocate for judicial reform, Justice Kokaram has been instrumental in shaping alternative dispute resolution frameworks marked by depth, versatility, and strong commitment to justice. Justice Kokaram was the chair of the Mediation Board of Trinidad and Tobago from 2010 to 2018. As chairman, he advocated the use and application of mediation as a means of developing a more peaceful and productive society. In March 2022, he launched the Peace Jurisprudence Clinic, the Healing Hub, as a component of the Students' Legal Aid Clinic and Wooding Law School. I please welcome on stage Justice Kokaram, and a round of applause for him, please. Next, I introduce Mr. Jay Chima, Senior Advocate, who is the chair of this session. Ladies and gentlemen, it is a privilege to introduce our chair, Mr. Jitinder Jay Chima. He is a leading authority in energy, natural resources, cross-border arbitration, and environmental law. Truly global in his practice, he holds the rare distinction of being called to the bar in India, Canada, and Africa. Before the Honorable Supreme Court of India, he serves as amicus curiae in the landmark PILs, including the defining Aravalli Hills, which is a very important issue for Rajasthan, and India's first ever climate change and carbon emissions litigation. He is also the author of the benchmark 2024 treaties, Climate Change, the Policy, the Law and Practice, which was released by 4 sitting judges of the Supreme Court. IFLR 1000 has recognized him as a notable practitioner for the year 2018, 2019, and 2020. He has been awarded as Scotch India Law Forum for his exemplary service to law in the year 2022. Please join me in extending a warm welcome to Senior Advocate Jatinder Chima. Now let me introduce our first speaker, who is Mr. Anil Changarot. He is from Singapore. Internationally accredited multicultural, commercial, and family mediator, arbitrator, adjudicator, and restorative justice practitioner with 3 decades of legal and appropriate dispute resolution experience across the Asia-Pacific region. He is an advocate and solicitor of Singapore, a solicitor of England and Wales, a barrister of Middle Temple, UK. Mr. Changarot specializes in complex construction, infrastructure, and environmental disputes. As the former chair of the Law Societies of Singapore's ESG Working Group and a member of the International Bar Association's Climate Change Working Group, he is at the forefront of bridging legal frameworks with restorative climate justice. He holds a Master of Science in Construction Law and Dispute Resolution from King's College, London, and NUS, Singapore. Please join me to welcome Mr. Changarot on stage. Our second speaker is Ms. Ranu Purohit. She is an advocate on record at the Supreme Court of India. Ms. Purohit is a versatile litigator specializing in environmental, commercial, and constitutional law. Her practice spans the Supreme Court, the Delhi High Court, and key regulatory tribunals like the NGT, PMLA, and NCDRC. Having previously served as a legal manager at the National Green Tribunal, she has handled critical environmental matters, including representing wildlife conservation organizations in the high-profile Bajan oil spill case. She is also a recognized authority on POSH and employment law, routinely conducting corporate workshops and advising on workplace regulations. She is an alumnus of esteemed ILS Law College, Pune, and holds LLM and is currently pursuing PhD in environmental regulatory reform. Please welcome Ms. Ranu Purohit. And the third speaker for the session is Mr. Ajit Sharma. Mr. Ajit Sharma is advocate on record at the Supreme Court of India. Since 2012, he has built a wide-ranging independent practice before the Supreme Court, the Delhi High Court, and the National Green Tribunal, representing private parties as well as major government bodies like the Income Tax Department and the DRI. His legal journey spans continents and elite chambers, having trained with legal stalwarts like Mr. Gopal Subramaniam and Mr. Janak Dwarka Das, as well as practicing cross-border corporate law at Dorsey and Whitney in London and Trilegal in Mumbai. Academically distinguished, he is an alumnus of Nalsar, Hyderabad, and holds LLM from George Washington University Law School and is qualified as Solicitor of England and Wales. Please give a hand to Mr. Ajit Sharma. On stage, please, sir. Now, to start the session, I hand over the proceedings to Mr. Cheema.
Mr. Cheema, sir, before you start, first of all, thank you very much, and thanks, Naman, thank you very much, and good evening, everybody on the dais. Sir, before you start, sir, I'm sorry I interrupted you. We have a tradition of welcoming you. So welcoming you all. So now may I please call out Mr. Dinesh Jalutharia to please come on stage and gift a planter to the speaker. First of all, to the session chair, Honorable Mr. Justice Vashisht Kokara. Then may I also request Mr. Ankit Raman to please come forward. May I also request Rahul Chaudhary to be ready. Sundarlal Kharolji also, I will request you also. And lastly, Ajit Kudi. I will request all of you to please be ready with it. Thank you very much, sir. Ankit, may I please ask you to come on stage and felicitate our chair, Mr. Jitendra Cheema. Thank you very much. Rahul, may I ask you to please come on stage and felicitate Mr. Anil Changarot. Yeah, please. Please come. Okay. Sundarlalji, can I request you? Yeah, please. Please felicitate Ms. Ranu Purohit. Now, may I please request you to come and felicitate Mr. Ajit Sharma. Thank you very much. Over to the chair. Thank you very much.
our session chair, Justice Kokaram, my esteemed colleagues on the dais, distinguished delegates, judges, learned senior counsel, guests who are assembled here for the Commonwealth Peace Mediation Conference 2026. Our session is devoted to the theme Climate Mediation, Water Sharing, Biodiversity and Sustainability, a subject that sits at the intersection of environmental law, institutional design, and urgent realities of our time. The questions before this panel is not abstract. They concern the rivers we share, the air our communities breathe, and the mechanisms through which law and dialogue can protect what litigation has struggled alone to safeguard. Over the next 75 minutes, we will collectively examine the statutory, institutional, restorative, and comparative dimensions of environmental mediation. I'll begin with a brief opening presentation to establish the conceptual framework, after which our three distinguished panelists will offer their perspective. This will be followed by a moderated panel discussion and an interactive session with all of you. I'll introduce my speakers and what they're going to speak a little later. But presentations you will hear this evening will traverse the full landscape of environmental mediation, from statute to institution, from liability to restoration, and from domestic practice to comparative experience. I'm confident that the discussion that follows will be equally rigorous. Let me first begin with my own presentation. I've just made a short presentation for all of you. Okay. So I'm going to be laboring with this sentence, so please bear with me. It's in Maori language. It says, Kwa u te wa, ko te wa ko u, which in English means, I am the river and the river is me. These are not the words of a poet. These are words of a legal settlement. In 2017, the New Zealand Parliament declared the Wanganui River a legal person with its own identity, its own rights, and its own guardians. This did not happen in a courtroom. It happened around a table through 5 years of structured negotiation between Maori people of Wanganui and the Crown. Through this mediation, the parties invented an outcome that no court in the world could have imposed. Yep. That outcome is Earth's jurisprudence in action. The recognition that nature is not merely a resource to be divided, but a living system with intrinsic value. And it confronts a truth we rarely speak aloud. Every person in this room wants two things simultaneously: a clean and sustainable planet, and economic growth, technological progress, and a first-rate infrastructure. The factory owner wants clean air for his children. The activist who fights for river charges her phone every night. This is not hypocrisy. It is the human condition. The tension between development and environmental protection is not a contradiction. It is a design problem, as you see in the slide. And the litigation which forces a binary cannot solve it. Mediation can. Next. But mediation is no magic. And the contrast on this slide tells us why. On the left, the Kaveri, a 130-year-old water dispute between Karnataka and Tamil Nadu. It was in news as of yesterday evening. No neutral mediator, no joint fact-finding, no confidentiality, and extreme political pressure on every participant. Our tribunal took 17 years. The Supreme Court provided no formulae for drought years. Every failed monsoon still triggers a fresh crisis, which we saw just yesterday. On the right is the Wanganui. When negotiations recommenced in 2009, the Maori reframed the question from who owns the river to how do we protect it together. The result was unprecedented. The river was declared a legal person, owning itself, co-guardians were appointed, and $80 million in redress was provided alongside a formal Crown apology. Lesson is not that mediation fails, it is that unstructured mediation fails. Next. So what does structured mediation require? 6 essential elements. Map before you mediate. Ensure no key stakeholder is excluded. Establish joint fact-finding, the approach that protected 85% of Canada's Great Bear Rainforest. Agree on the standstills, halt harmful activity while parties talk, or irreversible damage will outrun the dialogue. Negotiate interests, not positions. Uncover what communities truly need rather than trading fixed demands. Build on in enforcement. Submit settlements as consent decrees, combining flexibility with judicial authority and make outcomes transparent. The process must be confidential, but the final agreement must be made public. Next. This slide traces a similar friction. In India, a development project conceptualized in 2005 passes through an adversarial public hearings. Its objections are dismissed. It spends a decade or more in litigation before the National Green Tribunal. The Supreme Court itself has observed that prolonged environmental litigation hurts both the environment as well as development. Both sides lose. Next slide. So imagine a single reform, a mediation cell inserted between public hearing and a clearance decision, where proponents and communities negotiate safeguards, benefit sharing and monitoring with trained mediator. The NGT could formulate guidelines, establish expert panels, and refer suitable disputes over compensation, compliance, or remediation to mediation before litigation begins. Successful settlements would be recorded as consent orders with tribunal's full authority behind them. This conference, convened by the Commonwealth Lawyers Association under the theme Peace, Mediation and Rule of Law, is the right forum to recommend that Commonwealth nations pilot green mediation frameworks and embed mediation into environmental governance, not as replacement for courts, but as first indispensable step before courts become necessary. And my final slide. The Wanganui River taught us something profound. When we change the process, we change the outcome. Ko a ti wa, ko ti wa ku u. I am the river, and the river is me. Thank you very much for your attention. May I invite Anil, who's going to be our next speaker. Anil brings to this panel a perspective that challenges us to think beyond liability and towards repair. His presentation, titled From ESG in Conflict to Restorative Climate Justice, will examine the limitations of litigation and arbitration in resolving environmental and ESG-related disputes, particularly the costs delays and adversarial consequences that so often accompany conventional proceedings. He will propose the application of restorative justice principles traditionally associated with criminal law to domain of international mediation. His central proposition is both bold and timely, that environmental dispute resolution must move beyond determining who is at fault and must also focus on acknowledging harm, engaging affected stakeholders and agreeing upon measures directed towards remediation, rehabilitation, and future prevention. Welcome, Anil.
All right. Good evening, everyone. Thank you so much for that introduction. Let me just get started because we only have a little time. All right. So my topic is from ESG, environmental, social governance, conflict, to restorative climate justice. And restorative justice, for some of you who may not be familiar with it, it's a criminal practice. It's found in criminal practice where they go help the prisoners, ex-inmates, be restored to the way they used to be in community before they launched on their criminal activities, right? So my suggestion, and it's from a paper that I published in the Commonwealth Lawyers Association's inaugural newsletter on climate justice in April this year, together with a co-writer, Lenny Rahman from Brunei, all right? So basically, let me just start with what your Chief Justice has said. Mediation is no longer an alternate, but an essential instrument to achieve timely, amicable, and lasting resolution of disputes. And he said it when calling upon fundamental shift in how global cooperation and legal systems approach conflict during his lecture in the UK. All right, so very insightful points that he said. And if you take that down to ESG disputes, the point I'm making is that building peace through dialogue requires us to treat environmental conflicts not only as a contest over rights, but as an opportunity to establish responsibility, repair harm, and create sustainable coexistence. How do we do that? We start off with looking at a problem. Right? If you look at ESG problems and climate disputes, you realize that it's multi-party. Sorry, move on, please. Oops. I apologize, that was the quote. This is the next one. This is the problem, right? ESG and climate disputes are multi-party, technical, all right, and intergenerational. So it involves a whole lot of people and parties, not just the claimant and the respondent, so to speak. And the proposition is that in mediation, if you go down the path of adopting restorative practice, moves beyond just the fault and settlement to responsibilities, but repairs, prevents, and continues to stewardship the problem that they caused. And the model that I'm suggesting is that you need to have the public involved, you need to have mediation, and you need to have restorative implementation put in place. And how do you do that? Let's see next. All right. Okay, so you have to look at why ESG and climate disputes are slightly different, because there are elements of government and regulators involved. You have the business, contractors, and financiers involved. You sometimes have experts and scientists involved. You have the affected communities involved. You have civil society and public institutions involved. And you have future generations that are affected by the problem. Next. Now, litigation and arbitration is an adjudicative method. It is still very important, but the end result of that is mainly a financial situation, right? So whether you go into litigation or you go into arbitration, the matter or the dispute is settled financially at the end of the day, right? But that might not be the best resolution to resolve something that relates to the environment, it relates to the community that you would live in, right? So if you look next, if you look at restorative practice, sorry, just press one more. No, okay, so the slide before that didn't turn up. But it talks about harm, it talks about responsibility, it talks about repair, and it talks about prevention, all right? And then what the mediator has to consider is this. What must be repaired, by whom, by when, with whose participation, and how will the public know whether the remedy is working. So if you are sitting as a mediator, you get an opportunity to look at all of these with the parties. So who, all right, the affected people, what, whether the environment is affected, how, whether or not you take measurable steps in taking things forward, or the public value. So all of these have to be considered. Next. Right. Now, I propose that the 5 restorative approaches to mediation includes a rights-based, right? You know, you start off with looking at the parties' rights. You want to move closer towards what's the interest of everybody. You want to be inclusive. You want to be looking at evidence-led. You want to look at reparative, resorting to a solution that works for everybody. And you want to look at accountability at the end of the day, right? So not every case should be settled. Urgent relief, serious illegality, bad faith, severe power imbalance, or the need for precedents may require adjudication. So some aspects may need adjudication, but in a lot of the situations that involve environmental, social, and governance issues, you've got to look at it holistically. Next. Right? So the separate parts of what you need is the public law concerns, the authoritative determination, clearance, statutory standards, constitutional rights, offences, urgent restraint. That must always be there. But on the private side, if you look at mediation and conciliation, it provides you the best avenue of tackling problems of this nature, right? So you have warranties, you have the supply chain issues, you have insurance, you have financing, you've got disclosure, and you've got transitional costs involved in trying to put the damage that you caused back to the way it should be. And the third part is restorative implementation. You got to think out of the box, and mediation gives you that opportunity to think out of the box about what you can design to help restore the problem that you caused that may affect livelihood of the people and the community that are involved, and redesign an approach to try and solve the problem, not just financially, right? So that's the essence of what restorative justice can do. Next. Right, I set out the stages that if you're looking at restorative justice, and if you're really keen on taking this, you've got to look at the legal implementation and process and design. You've got to look at stakeholders and the right of holders mapping. You've got to look at joint fact finding. You've got to look at who caused the harm, the responsibility, and how that can be solved. You've got to look at the restorative options that you can have. You've got to look at legality and public interest validation, and then how do you put that into implementation. So now if you have a process like this that deals holistically with ESG, you know for a fact going down the path of litigation or arbitration is not going to work. Next. All right, so these are some of the building blocks, right? You know, if you go down the path of adversarial approach, you don't get the kind of solution that would be best in the interest of all parties. Right? And if you go down the joint fact-finding through the process of mediation, of course, fact-finding can happen in litigation, can happen in arbitration, but it's far more adversarial than having parties sit together in a mediation to try and see where the crux of the problem was to start with. And the result, you know, you have a shared approach to how you want to solve the problem at the end of the day. And mediation is the only way you can get there. Right? Next. I say that if you took a look at it holistically from the approach of restorative justice or restorative packaging, you know, you get ecological restoration, you got livelihood of the health measures, you got project design and relocation, benefit sharing, you got governance reforms, finance secured performance, independent monitoring, and how you adapt. So all of these elements are elements that are going to arise in major ESG-related problems that you face as we move along. All right, and it's already starting to do that. There's a whole set of case law in arbitration and in litigation that shows up how some of these climate change issues have not been resolved at that stage and cannot be resolved at that stage, and it's taken out of litigation and arbitration and moved into mediation. Next. All right. I set out some safeguards and how to keep mediation within the rule of law. You know, the issues of legality is important, power balance is important, independence is important. How do you secure the performance at the end of the day? Inclusive participation of all the parties. and then, whether or not there are any parties' interest that has not been taken care of, whether you want to consider that as well. Next. All right, for this conference, I'm making some suggestions. State the law as it presently operates, look at adjudication of the government, mediation, and the end game of what the community and what you deal for the community. Develop an environmental and climate mediation protocol. So you have that opportunity. You have the Mediation Act here. You have now an opportunity to possibly go down and set rules and regulations in support of the Mediation Act. Create a specialist multidisciplinary panel if need be, embed early dialogue into dealing with ESG issues, require transparent, measurable, and secure performance at the end of the day, and build a Commonwealth being dealt with by mediation through the process of restorative justice, but expanding it across the world. And I leave you last one with this, a suggestion that we make a commitment to this. We affirm that environmental and climate mediation, the courts, tribunal, and regulators protect public and intergenerational interests, enable meaningful participation by the affected communities, and translate responsibilities into ecological restoration, livelihood protection, accountable governance, transparent monitoring, and sustainable coexistence. Right? Thank you.
Presentation completes the architecture of this session by examining the comparative and institutional dimensions of environmental mediation. She will address the feasibility of introducing pre-litigation mediation in environmental matters, drawing attention to environmental impact assessment process. She will speak to the pressing needs for specialized environmental mediators, professionals equipped with both legal and scientific expertise, and will present comparative examples from jurisdictions where environmental tribunals have successfully incorporated mediation secretariats and court-connected dispute resolution and institutional framework. Welcome.
Very good evening, Honorable Justice Kokaram, my learned senior, Mr. Chima, my co-panelists, and a very warm welcome to everybody who's present here, learned senior advocates, honorable judges, and my dear friends. I think the very aptness of this theme, now we are examining and facing today, and what has been doctrinally now established is the environmental rule of law. And what environmental, it is always man versus nature, or development versus sustainability, or development versus the interests of the environment, or the anthropological creation and through dialogue. Environmental disputes pitched against conservation through court-based litigation, which is often arbitrary, is a dialogue-driven process, which offers a unique alternative to empower local communities to work collaboratively on solutions. In the Indian context, mediation can help resolve issues which require prolonged litigation. The NGT Act, if you appreciate, will in itself provides that a 6-month period is the timeline to resolve environmental disputes. Now it must be thought through that in 6 months, if an environmental dispute is not brought to an end, the damage to the environment has already occurred, and what remains there is only restorative measures. On the contrary, what I propose is, when mediation forms a part of the pre-lit dispute resolution, it offers indigenous communities, developers, and stakeholders to have a dialogue where they can resolve their concerns without pitching environment against the development debate. Next slide, please. What I therefore propose to examine and highlight today is, what is the feasibility of having environmental disputes in India, and therefore the need for specially trained environment or green mediators, as I would choose to call them. Also separately, we will see how nations across the globe are now shifting to mediation in environmental disputes, which is unique at the moment to our country, and how those environmental disputes where mediation has taken place have resulted in enormous success for both development of the economy and conserving the rights of the local tribal population. We all are aware that now in India, the Commercial Court Act provides for a mandatory pre-litigation mediation. This allows the party to come and resolve their disputes prior to entangling themselves in the prolonged process of court-adjudicated adversarial litigation. The results for this have been a mix because the Environmental and Economic Advisory Council has found that nearly 98% of the mediations have remained to be a non-starter. The reason may be different in different scenarios. It has not been managed procedurally. The parties have never become aware of the opportunity to be able to resolve their disputes through mediation or having the relevant expertise of mediators. And the statistics would show here that only approximately 1% of these disputes that have been referred to mediation have actually resulted in a successful settlement. However, in the environmental aspect, the EIA notification in itself provides the process of a public consultation. And what I seek to therefore propose is that this public consultation is in itself a process or a channel through which dialogue can happen between all the stakeholders, the project developers, the regulatory authorities, and the participants and local tribal population. And therefore, when the Act gives an opportunity for a public consultation, mediation as a mechanism to proceed without therefore challenging each and every environmental clearance before the court could be a way where the concerns of indigenous communities, developers, and the regulatory bodies can be addressed. Honorable Justice Nagaratna, Honorable Judge of the Supreme Court of India, recently stated that specialized mediators in environmental disputes are necessary and proposed that a mediation council be set up with a panel of accredited green mediators who are trained in environmental law, climate science, public policy, and socio-economic impact. Justice Nagaratna drew parallels to the US EPA's Environmental Collaboration and Conflict Resolution Program and suggested that India train a specialized cohort of mediators or green mediators, as we would call them, highlighting that mediations in India today are still ad hoc, and therefore there is a necessity today of a formal code of conduct and a national mediator training curriculum specifically in the environmental field to have environmentally trained expert green mediators. Looking at where the law currently stands, I must flag for this panel because it goes to the heart of feasibility that the Mediation Act 2020, which for the first time gave a comprehensive framework for mediation in India, currently unfortunately excludes environmental disputes falling within the NGT's jurisdiction from the first schedule. Environmental harm often affects a very large number of third parties and public interest and needs authoritative adjudication rather than a private settlement is what was the proposition. The concern is understandable, but the Act in itself leaves the door open. The central government retains the power to amend this by notification, and that is where the feasibility question finds a resolution. Not whether mediation is theoretically suited to environmental disputes, but whether we as a profession can make the case supported through evidence and categories where environmental disputes deserve to be brought to the mediating table. This isn't a hypothetical debate, as I would say, because while this concern was brought before to the Parliamentary Standing Committee by the Bombay Bar Association, that let some environmental disputes be referred to mediation, the answer was that disputes such as land acquisition or where regulatory authorities are involved may not be amenable to mediation. Therefore, let us look at what cases are such which can be referred to mediation in the environmental disputes. cases alleging mass ecological irreversible damage, where harms reach beyond the parties, genuinely requires the tribunal's authoritative adjudication. But disputes over monitoring the conditions of a mining project, or phased implementation of a rehabilitation package, or coordination between different departments on a river's ecological damage, management of solid waste, etc., or disputes involving private parties pitted against the developers can definitely be amenable to mediation. This is what mediation is built for, and court orders struggle to design. The feasibility argument isn't an all or nothing. It is about revisiting the choices already made. The scale of the problem makes this urgent. Today, we will see the pendency of disputes, specifically before the National Green Tribunal, which is the foremost green court of the country to resolve all the environmental disputes. There are currently more than 5,000 pending cases before the NGT. I am repeating myself, but it is very important to note that the Act in itself provides a time frame of 6 months for the resolution of environmental disputes. 6 weeks is what the tribunal grants as the timeline for filing of responses, coupled with adjournments, different parties filing different replies, the bench availability, the appointment of members that the NGT constantly struggles with, hardly makes that timeline attainable in even a single instance. Therefore, the question I need now to address, and I propose for the panel also to give their suggestions to this, is the requirement of having trained environmentally expert green mediators. Today, under the mediation and conciliation rule, the panel of mediators may include retired judges, senior advocates, or experts and professionals having at least 15 years of standing. The last category is in the right instinct. It allows a hydrologist, a forest ecologist, or a rehabilitation specialist to sit as a mediator. This remains, however, discretionary, and the accredited tag for environmental or sector-specific mediators in India today, as per the Mediation Council of India, which is envisaged under the Act, has yet not been operationalized. The benefits of mediation in such context, although has been well documented, it reduces the time of the litigation, can produce creative outcomes which at most often may not be possible through court litigation, and the opportunity for parties to sit together can bring the resolution. Advocates argue that appropriate legal safeguards and stakeholder engagement, green mediation can complement the court orders, helping resolve environmental conflicts more effectively without sacrificing the goals of development. Handling environmental cases well in mediation requires trained and multidisciplinary mediators. The ADR system, for instance, in the US Udall Foundation case, maintains a roster of environmental conflict resolvers. In the Indian system, if we look at, I would propose that creating something similar to what we have attached to the Supreme Court and the High Courts in the form of a mediation cell. For instance, what we have as Samadhan with the Delhi High Court. A similar mediation cell attached to the NGT, which offers the parties an opportunity to have a resolution, a dialogue, prior to entrenching themselves in the rigors of litigation, can be a possible solution. It would ensure consistency, credibility, and an opportunity to have their trust in the process of resolution through a dialogue. The NGT Act in itself provides expert members, and the Act defined expert members as somebody having a postgraduate degree in physical or life sciences, with a doctorate or a master's in engineering or technology, with 15 years of experience, of which 5 must specifically be in the realm of pollution control, hazardous substance management, environmental impact assessment, climate change management, biodiversity, or forest conservation. Thus, the Act in itself lays down the qualifications that could be adopted for having green mediators. And the resources are enormous in terms of having expert members who formerly served the tribunal. Therefore, I say that we are not without a starting point today. India has already run, outside any formal mediation label, facilitated multi-stakeholder dialogues that succeeded precisely because they involved persons who understood the subject matter. The Chilka Lake dialogue in Odisha, which helped revive traditional fishing livelihoods after competing claims between the fisher folk and the prawn farming interest, or they facilitated negotiations in Uttarakhand forest disputes between the forest authorities and local communities are some such examples. These were not run by generalist mediators. They worked because the facilitators understood the needs of the local population. The international model now that I propose to present before you, the next, is the New Zealand's Environmental Court. The court in itself appoints environmental commissioners, specifically those who combine legal and technical expertise in environment along with ADR training. The Act established under the Resource Management, the court established under the Resource Management Act offers court-assisted mediation with environmental judges, only rarely concluding matters, and the norm is reference of these matters to environmental commissioners, who are required as a condition of appointment to have training and experiences in ADR. The experience also offers a powerful example of what collaborative stewardship can look like. The Wanganui River settlement was the case in point. Another example that we may. This is some of the data that I'm sharing where environmental disputes have been brought through settlement by way of mediation. The other example that I was wanting to suggest is in the case of Australia, where the environmental and land courts run both conciliation and court annexed mediation. And 60% of those cases are resolved through mediation. The US Environmental Protection Agency has a climate and energy environmental collaboration program which brings the EPA, communities, and businesses together in mediation and facilitation for pollution and climate issues. Coming to our own country, the Indus Water Treaty of 1960, a vital water sharing impact between India and Pakistan, was brokered through a third-party mediation initiated by the World Bank. Thus, what I therefore conclude is not that we have not the requisite expertise, but we are just a step away from the starting point. Environmental disputes need not be pitted as a debate of man versus nature or sustainability. The idea is essentially to have a dialogue, to understand the concerns of the local population, the tribal regions, the area-specific ecology, and the stakes that are at place in development and economic growth of the country. The conference, as the theme suggests, is for mediation and rule of law, and therefore mediating in the realm of rule of law, especially in the environmental rule of law, is the need. Thank you so much.
Anil, Jeet, may I invite you? Our next speaker, last but not the least, is going to make presentation which addresses questions of considerable practical significance. He will examine the statutory exclusion of environmental disputes from the scope of Mediation Act, whether this exclusion might be addressed through executive notification without legislative amendment. He will then turn to conspicuous absence of mediation referrals by the NGT, distinguishing between disputes involving broad environmental policy and those involving localized, compliance-oriented matters that may well be suited to mediated resolutions. Finally, he will explore whether major polluting industries such as cement, mining, power generation might develop voluntary self-regulatory standards and dispute resolution mechanisms of their own. His analysis will bridge the gap between what the statute currently permits and what the institutional imagination might yet achieve. Welcome, Ajit.
Thank you. Honorable Justice Kokara, Shri Jay Chima, learned senior advocate, my fellow panelists, learned senior advocates, advocates, my colleagues at the bar, ladies and gentlemen. First of all, let me begin by thanking the organizers, the RSLSA, the Commonwealth Lawyers Association and Nivaaran for organizing this and bringing us all together here to discuss some of the very important topics centered subject-wise on how mediation will affect various themes in law. We are first of all we have the privilege to start off with the theme of mediation and environment. Now, this is one theme where which is particularly relevant because environment is one area where mediation is completely absent, so to say, in India at this point in time. There is a mandatory, as my co-speaker pointed out, requirement, a statutory requirement for mandatory mediation in commercial disputes, in property matters, in matrimonial family matters. Sorry, okay, thank you. But as far as environmental matters are concerned, there is a complete absence of mediation. Not a single instance where the tribunal or the Supreme Court has referred an environmental matter for mediation. So therefore, I think this particular discussion holds immense importance, particularly for members of the bar here in India, because this is environmental disputes going to mediation is something that it does not occur naturally to a lot of us who are practicing and litigating daily before Indian courts. So the punchline theme of my submissions, of my discussion here will remain that let us explore the possibility of mediation in environmental matters, because not just because it's prompt, because it works in other countries, but because it's solution or result oriented, especially in a country like India. All right, can we move to slide 1, please? Okay, that said, at this point in time, the legislative framework as it exists in India is not one which encourages mediation of environmental dispute. It actually restricts. Now, the Mediation Act, as my colleague pointed out, is a recent 2023 enactment that was passed by the Indian Parliament. Very well. The Parliament has now indicated to the people that mediation is mandatory, must be resorted to. But Section 6 of the Act excludes certain themes, certain disputes from being referred to mediation altogether. One of those categories of disputes is environmental disputes, jurisdiction over which the Green Tribunal has. Those disputes, there is a complete statutory embargo from being sent to mediation. So at this point in time, the legislature has said that as far as environmental disputes are concerned, we will not send them to mediation. Thankfully, however, there is an administrative requirement of notifying Section 6, which has thankfully not yet come in. So this Section 6, which imposes a statutory embargo on not referring environmental disputes to mediation, has not yet been notified. And I hope it continues this way to exclude it. Even if it is notified, there is only an executive action that the executive of the day needs to take the environmental disputes out of that list, which essentially contains a lot of criminal law, public law, and other matters which should not be referred to mediation. So therefore, one needs to make representations to the legislators, and they need to mull about removing this Section 6 statutory embargo, not because its perception doesn't look good, but because you are foregoing the possibility of referring a whole host of disputes to mediation altogether. Second is the NGT Act, the Green Tribunal Act. We are privileged, in India, one of the few countries in the world to have a dedicated Green Tribunal. My colleague pointed out Australia's example. That was probably the first country to have a Green Tribunal. So does New Zealand had one. And by and large, following the model of our common law partner countries, we in India have also enacted one. The NGT Act gives a lot of power to the NGT to make its own rules, the way it functions. Perhaps that's one school of thought, that the NGT the chairperson and the other administrative members could sit down together and mull the possibility of introducing some rules or an administrative mechanism to refer certain category of disputes to mediation. Third is the Environment Protection Act, Air Act, Water Act. None of these three enactments in India right now refer to mediation or even acknowledge the possibility of some form of a mediation or conciliation or any form of alternate dispute resolution. Now, these are fairly old acts, as you would have seen. The Air Act is 1981, the Water Act is 74, Environment Protection Act is 86. A lot of them were introduced in the Parliament because of Supreme Court's push and recognition for environment as a theme. Therefore, a lot of these acts are old, perhaps outdated, perhaps needing one that need massive amendments as well, and an acknowledgement that yes, even in these 3 or 4 statutory enactments, some form of alternate dispute resolution, preferably mediation, should be acknowledged. Its space should be acknowledged so that the regulatory authorities don't just come charging on violators and say polluter pays and therefore I have all the powers and I'm going to shut you down and then adjudication start later on. But let's sit down together and address the concerns. All right, could we move to slide 2? Thanks. There are tons of international conventions and agreements which refer explicitly to mediation, negotiation, conciliation, finer legalese. Now, India, of course, is a party to the UNCLOS, United Nations Convention for Law of the Sea, which contains whole chapters and a large number of provisions on protection of marine environment. So I've just culled out a couple of examples here to indicate that, look, India has on an international platform, along with almost 100 plus countries around the world, have come together and are signatory to documents which contemplate protection of environment, amongst other things, but where protection of environment is the major theme of these international conventions. And in the event of a dispute which pertains to protection, conservation of environment, in the event of a dispute arising out of these conventions, mediation is an acknowledged dispute resolution mechanism. So therefore, and India is a party to this. So therefore, on an international level, while we've acceded to the fact that yes, if I have a state dispute with another party to these conventions, I will resort to mediation. Internally, while working our own environmental laws, we have absolutely excluded the possibility and imposed a statutory embargo of resorting to mediation in environmental disputes. That approach needs to change. Next slide. Thanks. Now, these are just a couple of examples. My colleagues have already pointed out in the common law world itself, and I'm repeatedly relying upon common law instances because there is a basic on first principle conceptual level similar framework that we all share. South Africa has a very progressive liberal legislation when it comes to protection of environment, and a provision in their environment protection, akin to our Environment Protection Act in their domestic legislation, contemplates the possibility of a mediation. My colleague has given statistics about US and Australia. I personally don't support the way that US is heading of mediating a large number of public law disputes as well. But yes, mediation in US has been incredibly successful. One of the studies suggesting that almost 78% of the disputes referred to mediation in US culminated in a settlement. But yes, US, Canada, Australia, New Zealand, South Africa, all of these countries specifically, Japan as well, a non-common law country, contemplate specifically the possibility of mediation qua environmental disputes. So I'm not saying that we should just blindly copy other jurisdictions, but it's a tried and tested mechanism. Let us study how they work and try and emulate the good points that we can see from other countries. The only reason I mentioned this Churchill versus Merthyr recent judgment passed by the English courts is only because while reading it I found it very interesting. This judgment contemplates the policy of approves compulsory mediation even in the face of an objection by one of the parties, because we keep hearing that mediation foundation is based on consent of parties, and in the event one party withholds consent for no rhyme or reason, mediation will fall flat at the face to begin with. But here the English courts have upheld the principle that yes, in certain disputes, here was a land dispute, and nuisance disputes and other tort disputes, mediation must be resorted to, and compulsory mediation must be resorted to. All right, next slide. Now, I touched upon this briefly earlier. The National Green Tribunal has been working fabulously well, in my personal view, in our country. There are about 6,000 odd disputes that are pending. About 4,000 are disposed of every year. 5,000 fresh cases are filed every year. So just imagine now, this new statutory tribunal has come into existence from 2010. Altogether, over these 16 years, heard about 20-odd thousand cases, made a massive difference to our natural resources, forests, wildlife sanctuaries, hills, rivers, eco-sensitive zones, developing environmental jurisprudence over so many years. Now, of course, it can be made a lot better, it can be made more efficient, its jurisdiction can be expanded, but the work that it has done, no doubt, deserves applause and praise. That said, there is a scope for improving administratively how it functions and to its ability to be prompt in disposal of cases. And to that extent, I suggest that like in other forums, like in commercial, property, family forums, there should be a dedicated mediation cell in the Green Tribunal as well. At this point in time, it's a possibility that everyone is closed to the idea, even the idea doesn't come across to many people that Green Tribunal having mediation will just not work. It's a non-starter at this point in time, but it should. And I'll tell you why, because as somebody who practices in NGT regularly, there are a lot of disputes in NGT which have a very small public law element, but a much larger private law element. So for instance, disputes like non-compliance with term of an environmental clearance, that some developer has been given an environment clearance, he or she, the developer, will have to make sure that it's a dust-free environment is retained, there is a wall which is built around the building construction site. So those kind of minor non-compliances, immediately a litigation is filed before the NGT. Now those are the kind of essentially private litigations where the tribunal can say that, look, Mr. Builder, there is a condition you have to comply with, and if you have not complied with, I'm going to send both of you, the litigant and the builder, to a mediation cell where a mediator will see that, yes, if there is a non-compliance, how much time do you need to comply with it? And that is not a issue which should become adversarial, which should go to the court, and the court must spend a lot of time, give a detailed judgment on it, which will be challenged in appeal, and so on and so forth. So therefore, a large number of such cases where there is, a road is being built and that causes a traffic jam on the road, leading to somebody file a litigation in NGT saying that there is increased air pollution because of a particular activity. So there are a lot of those cases. Out of 20 or 30 odd cases listed every day in NGT's cause list, 2 or 3 cases will be cases that essentially involve a private harm, not a public harm. So by public harm, I refer to if there is a discharge of sewage in a river or some kind of harm done or a damage to a natural resource as a whole, then yes, one requires adjudication followed by consequential imposition of environmental compensation, penalty, so on and so forth. You must lay down the law. But in several minor violations of environmental clearances which can be remedied, where the other party only seeks some perhaps time to remedy the harm done, one doesn't need adjudication, in my personal view, in the Indian context. One other suggestion I have is in the event NGT were to introduce some form of mediation, or at least think about the possibility of mediation, then in Supreme Court and the High Court in Delhi, whenever notice is issued and the notice goes to the respondents that, sir, somebody has filed a case against you, now a copy of the petition is being served, the notice itself carries a paragraph that mediation is an option, you can explore the possibility of mediation. NGT also issues about 15, 20, 30 notices every day to various litigants, private, public, state entities. Well, they can also add in their notice format itself that, look, you can engage an advocate, appear on so-and-so date, otherwise it will be decided ex parte. And right at the bottom, the possibility of legal aid and mediation is a possibility that you can explore, so that people don't disassociate environment and mediation. They start associating them together. All right, and we can move on to the next slide, please. Thanks. All right, categories of environmental disputes that can perhaps go to mediation. I've touched upon this briefly. Essentially the theme is conceptually disputes that are private in nature and involve less of a public harm should go. But why would mediation in Indian context? My colleague pointed out that 98% of the cases referred to mediation turned up in a failure. Only 2% cases were successful in mediation. So what is the big draw for mediation in environment? I think, in my personal view, the big draw is twofold. One, in environmental cases, harm done is often irreparable if there is prolonged litigation. Mediation will ensure prompt resolution of the dispute, maybe not entirely to a litigant's satisfaction, but yes, it will ensure prompt resolution to the disputes. And lawyers also are very important to this prompt resolution, because if lawyers suggest to their clients that, no, let's file a reply, let's keep fighting, then perhaps the litigation will continue across all the appellate forums. But so therefore, we must also suggest to our clients that, look, if there is a non-compliance, we can resolve it by way of a mediation, by way of a consent order, by admitting to some part our harm, and then the other party would not insist on environmental compensation and pursuant to polluter pays. So that is one, prompt dispute. Immediately notice is issued, court will refer you to mediation. Within 3 or 4 weeks, hopefully parties can come together and resolve the issue. That's one charm of mediation when it comes to environmental cases. The second issue is that once there is mediation, once there is a mediated settlement, there is no question of any appeal then. So the litigation will not drag on. The list will end there and then. I would rather take that chance that the mediation takes 2 months or 3 months rather than the litigation being prolonged across the appellate stages for a year or two. So therefore in India particularly, I believe mediation will be result oriented more than anything else, given especially how burdened our courts are. My colleague pointed out 6,000 cases in a tribunal which is only 16 years old. They are pending right now. It doesn't have time to adjudicate so many cases, and new cases are being filed every day. So therefore we need to burden the courts with hearing, adjudicating public law disputes which will lay down the law, which will develop the environmental jurisprudence, rather than burdening the court with all kinds of private law disputes that are likely to be settled if with the proper intervention of trained mediators and lawyers who are sensitive. All right. Can we move on to the second slide after this? Yes, the next one. All right, and that said, I want to just part with a concluding thought that I think has been so far not fully discussed in India, is self-regulation. Now we see in information and broadcasting sector, several broadcasters have come together to self-regulate themselves. Print press has come together to self-regulate itself. I think this consensus building as part of self-regulation is also an offshoot of mediation. So therefore, I often suggest this to my colleagues in court corridors that look, some of the major pollutants in India, thermal power plants, cement manufacturers, you pick up those 3 or 4 big buckets of major pollutants in India and put their industry representatives together in a room so that they can self-regulate themselves and come up with a code or an SOP that that these are the things that we have to monitor, these are the things we have to make sure all environmental clearances and their permissions and their conditions must be strictly complied with. These are the point of contact in our company. There must be an SOP in place. And the reason for that is this: if there is a SOP in place by an industry association, let's say FICCI or CII says that our thermal power plants have come together, 10 of these, and formed some kind of an SOP, then imagine the impact it has. It internalizes environmental discussion into their administrative decision making. Right now, the boards of these companies will probably prioritize other things over environment. There are several other compliances. Environmental is probably ranked 10 or 11 or somewhere. But the moment you say that, all right, I have to depute a senior person who will be in charge because there is a meeting next month for all industry representatives to discuss our common environmental compliances, then you're elevating the environmental discussion significantly internally. And that develops some kind of a formal procedure to ensure compliance. So therefore, I would suggest that in addition to these statutory compliances are obviously there must be some kind of self-regulation. And it's good for the industry as well, because as we have seen in US, it's actually the businesses which prefer environmental mediation more than than public interest litigants. So even in India, it's very much possible, because if the businesses, if some major pollutants come together and say that, sir, we have made a 10-point guideline to ensure that environmental compliances are placed in order, it instills confidence in courts of law as well tomorrow. The judges will also think, lawyers will also think that, all right, this is an industry which has come together, formulated something, given it importance and taken some action at it. So let me not pass some kind of an interim order shutting down the industry at an interim level. Let's give them a chance to implement their SOP and the statutory framework, because the intent to comply is not missing. So therefore, self-regulation is something that we must see amongst the major pollutants as well. With that as a parting thought, thank you all. Thank you.
We'll ask him to give the concluding remarks. So, thank you, co-panelists, for your wonderful presentations. We are going to skip the discussion part of it and straight away go to Q&A session so that we can field some questions, because the paucity of time and the inaugural program starting at 6, we will be happy to take questions from the audience. And we'll build the discussion around those questions. Can you give the mics in the audience? Please identify yourself, and a precise question is what we are looking forward to.
Hi, good evening. Great presentation by all of you. I'm extremely impressed. Thank you so much to each one of you. You know, like in India, we do barely have any environmental mediation, except the Indus Treaty, I think, which happened thanks to the UN, and nothing else really. I was just wondering, if you're looking at the pollution of Delhi, is that something which could be mediated, because there are so many stakeholders and self-regulation, as Ajit mentioned? Maybe that is something that would help. Your comments, Ranu and Ajit.
Please go ahead. Ajit? Can you get the mics going here?
Thank you. I think it's definitely something that one must explore. Yeah. Okay. I think it's definitely something that one must explore. The possibility of resolving in some part Delhi's air pollution by mediation. Because see, even in Delhi there are certain major air pollutants, major polluting industries, thermal power plants, vehicle manufacturers. So you could bring 2 or 3 major pollutants, the representatives of these industries together, so that they can come together and say that, all right, these are the statutory compliances which we will carry out in this form, with these timelines, with these penalties, with these risks. Because right now it's essentially whoever you catch polluting, you know, that kind of an approach will just not work in creating a permanent solution. So identify the major pollutants, somebody who contributes 20% pollution, somebody who contributes 10% pollution. If you're able to deal with these major pollutants, I think a big chunk of our Delhi air pollution problem can be resolved. Of course, the retail segment, the farmers, individuals, all of us, that will remain a big part, which perhaps may not be mediation may not work, and at the same time the strict enforcement law also may not work there. People will just have to change their habits and attitudes in the way they live and the way we all live. But yes, I think some major pollutants, they can be dealt with before the strict action of law follows, which we are all waiting to see. Mediation can resolve. Ranu, I don't know if you want to add something.
Can I just add a point as well?
Thank you so much, ma'am, for the question. Yes, thank you for your question, ma'am. Shireen ma'am has been a senior mediator and a senior advocate at the Supreme Court of India. So informally, I will say that all the learned senior mediators, I think if they act together, there's nothing, especially in the NCR, that we cannot resolve. Having said that, I feel every time there's a matter coming up before the NGT, there's a lot of fight inter se between the regulatory authorities. This is not my job, the Pollution Control Board should look into it. No, this is not my job, this is the Jal Board's job. So when it comes to vehicular emissions or air pollution in Delhi, the industries would say it is not our job. The DPCC would say it is not our job in isolation to manage it. The CPCB says it is not our job because the DPCC has to look into it. Then somebody comes and says, no, authorities at Haryana should look into it because, you know, the crop burning is happening there. Essentially, it has to be a dialogue. And any form of resolution, therefore, to my understanding, if it is only the authorities coming together and resolving that we do our fair share bit and therefore help reduce, if not entirely eliminate, will facilitate this process of addressing the issue of air pollution, specifically in the NCR, to quite a great extent, to my understanding.
Yeah. Could I just add a quick point? Coming from Singapore, where mediation is entrenched in our system, and we have the Singapore Convention on Mediation, a matter like this would be prime for it to be dealt with by way of mediation, right? A couple of quick points on that is, one, if you look at it any other way than mediation, you're looking at penalizing the people who have caused the problem, right? But the point of the matter is that you don't want to try and penalize them. You want to sit with them and try and solve the problem. So it's a perfect example of why you'd want to bring them to mediation. And if you don't have that culture of mediation, sitting with their parties and explaining to them what mediation could possibly do for them without having to go to court, without having to be penalized, being punished, it's an incredible opportunity for them to come to the table. And the minute you have them at the table, you move away from the party's position and get to their interests. A solution would be, and it would be a perfect example to start a clear-cut mediation process in environmental issues, but if you start on something like this. Thank you.
Anybody else?
This is to, could I request Justice Kokaram? This is for a broad international mediation scenario.
Keep the mic next to you.
Hello, yeah. So mediation fundamentally it is voluntary. It is a voluntary process. When so, there are a lot of we are hearing.
What is the expectation then? Do the judges themselves go and see or address the environmental concerns in an area? How do you do the fact finding? So all of this is essentially then given to a committee or outsourced, as it is infamously reported often. But what these committees are then doing is they are coming together, and essentially even in the realm of say public law, where the stakeholders in an environmental dispute are regulatory bodies, large number of citizens also, and then there is scientific data. These data is prepared, analyzed, assessed most often by these committees. So the idea when it is to have a dialogue, a committee is an appropriate forum where even a mediation could take place, is my suggestion.
So if I could make a small suggestion, sir.
Excuse me, can I just ask Anil and Ajit to be very quick in the responses, and then we're going to request Justice Kokaram to make
from my point of view is that if you go down the path of mediation, you can take the science out of it. You don't need the science, because the science is fact-finding and decision-making, right? The point is you want to get them to mediation to see whether they come to a settlement that solves all of the problem in the community and so on. But if you go down the path of strict science analysis, it might become adjudicative in nature.
I think in a country like India particularly, it's very important for these large public law related issues, one must have all perspectives. Having all stakeholders on the table is, I think, imperative in my view, because everyone brings in their own perspective. The scientist will bring in his perspective and the developer his. So having everyone on the table is the first task, I think, and then you'll hear voices, people will come down together to a consensus.
If I may.
Okay, I would request Justice Kokaram now to make his final remarks. We are running out of time actually, so maybe whoever has a question we can handle at the coffee time.
Thank you.
Everyone, Mr. Chima, panelists, peacemakers all, it's a pleasure to be here. Time is against us, and this is a wonderful conference to reason together on the value of mediation. And I challenge my law students every year with a case scenario in our public law seminars at the law school, in which I asked, what should be the recourse to deal with the protection of a large acreage of an environmentally sensitive area of the rainforest, which supports huge indigenous trees? Those trees have created a delicate ecosystem, supporting rare plants and wildlife. The trees are revered by a tribal village living in the forest. But a state authority acquired a license under a Land Acquisition Act to build a university in the forest and started clearing the land. But the license was acquired in breach of the regulations. Of course, all the students responded by saying that the villagers have a right to bring an action and to access the public law courts to protect their constitutional rights to due process. But I asked them, if the villagers had no means to access the courts, what if there was mothers who wanted their children to have education? Who would speak for the trees? And would mediation have been a more appropriate mechanism to deal with the conflict? Obsessing over rights without giving thought for a suitable mechanism to reconcile deeper interconnected issues between disputants that live in community with the environment gives environmental mediation a perfect platform from which we heard from our speakers today, in which dialogue, consultation, and working out a common agenda of future joint action is much more an imperative as we draw near to existential threats to our existence, especially for small island states. I take inspiration from an Indian decision, Muhammad Salim and the state of Uttarakhand, where they had conferred jurisdiction personality for the rivers Ganga and Yamuna. And one of the judgments said this: rivers are gasping for breath. We must now recognize and bestow rights to Mother Earth. It foreshadowed a recognition that we need to protect Mother Earth, that our human rights are linked to the preservation of our environment, that there exists the duty not to cause harm, and there's a duty to protect our environment as a generational issue. Climate change and climate justice, from what we've heard from our speakers, is a metaphor of global conflict, of the interconnectedness of the human community, and the constant tensions between the desire to exploit scarce resources on the one hand and the needs of the community and the protection of a sustainable environment on the other. An environment that sustains life is a natural state of being, and the degradation and exploitation of it without thought disrupts a natural state of harmony. So the very issue, which is the source of our conflict, is our interconnection as living beings on this earth, making adversarial processes so much unsuitable for the resolution of those types of conflicts. I fast forward to 2025, and especially for the Caribbean, a significant landmark advisory opinion was given by the International Court of Justice through an adversarial model, where it affirmed the states have legal obligations to protect the environment. But what was at stake? From the Bahamas' point of view, ocean warming and ocean acidification has damaged several ecosystems, including coral reefs. Man down by the International Court of Justice was an advisory opinion. It was considered a landmark opinion. It confirmed climate change as a human rights issue, and it affirmed that states must develop ambitious climate plans to achieve progress. And it also asserted that people affected by climate change deserve full reparations. But I think we missed the boat. This was an ideal situation for global peace mediation for environmental justice. How is the greater ambition to be achieved from this judgment? How long is the journey for reparatory justice? Will this judgment polarize the North and the South? Will there be retaliatory tactics? How is loss and damage actually to be achieved in real terms? Are there true winners? And so from our discussion today in our panel, we've discovered that a mediative system that progressively, through an organized process of understanding who are our stakeholders, preparing your conflict or the separate views on a conflict constructively in a preparatory phase, engaging in a collaborative method of communication in a mediative phase, and then implementing an agreement through the judicial system is the preferred option. It is time for us to follow the call of our panelists to build the bridge of mediation and to advocate for change to deal constructively with environmental issues, to deal with process which focuses on peaceful outcomes, to view environmental issues through a restorative justice lens, to affirm responsibility, to ensure that the voice of all is heard and assimilated in joint action, to, as Ranu said, preempt environmental disputes from even occurring, and then to synergize, as Anil was saying, mediative efforts into our legal structures and reform the way we view litigation on the back of mediation. In that way, we pivot the view that mediation exists in the shadow of law and reorient that now for mediation to take its pride of place as essential to environmental justice and environmental rule of law. The proposals that the panel makes this afternoon is an urgent one: to redesign, to rethink an architecture for achieving environmental peace collectively, to resolve conflict positively for a world gasping for breath. Thank you.
For this enlightening session with some practical inputs, I thank the entire esteemed panel as well as the chair. May we now have the presentation of the mementos to the chair as well as the panelists.
Thank you, Naman. Thank you, chair. Thank you, everybody, dignitaries and dais. Now we come to the souvenir presentation to our dignitaries. May I first of all, I'm calling out the names of people, those who will be coming and presenting them. So I'm calling the name Mr. S.P. Soni, Mr. Bharat Bhushan Pathak, Mr. Hanuman Sahai, Mr. Sanjay Kumar Malviya, and Mr. Kiran Kumar Chauhan. I will request you to come near to the dais so that we can finish it up in a moment, because at 6 o'clock sharp we'll start with a second event. Mr. Bharat Bhushan, please come on the stage and give a souvenir to the session chair, Honorable Mr. Justice Vashisht Kokaram, Judge, Appeal Court of Bahamas. Thank you. May I request Mr. S.P. Soni to please come on the stage and present a souvenir to the chair, Mr. Jatinder Chima, Senior Advocate. Thank you very much. May I request Mr. Hanuman Sahai to please come on stage and present a souvenir to Mr. Anil Changaroth. Thank you very much. May I request Mr. Sanjay Kumar Malviya to please come and present a souvenir to Ms. Ranu Purohit. Thank you very much.
May I now kindly request the entire panel.
There's one more name, Naman. Okay. Now last I request Kiran Kumar Chauhan, Mr. Chauhan to come on stage and present a souvenir to Mr. Ajit Sharma.
finished it in time.
Very much. A good cup of tea.
Thank you very much. It's over to you, Naman.
May I now request the entire panel to come in the front for a group photograph, please.
Thank you very much. With this, the pre-conference sessions culminates. अब हम कक्ष में ही विराजे रहेंगे क्योंकि समय हमारे पास थोड़ा कम है और हमारे अतिथिगण बस कुछ ही क्षणों के अंदर पधारने वाले हैं। तो आप सभी से निवेदन है कि आप सभागार में ही उपस्थित रहें।